Hmm.
I was asked to serve on the opposite party for decision of just for inclusion in that. Shall I do a washing matter?
Just for inclusion. You have served. This is for which year? 24. Achha.
Order of party on the pocket.
Hmm.
They are getting the list.
Okay. Wait in আসবেন contested application আনবে সার্ভিস করে দিয়েছে তো contested application promotion down
Number one. I'm for the petition number.
yes
But there is a settlement between the parties. The parties are husband and wives. But actually, the problem was the difference in priorities. The
difference in
priorities.
okay
The husband actually, I have explained the same in my paragraph number 4. If I be allowed to place the paragraph number. The opposite party number 2 used to get involved in debates and something. The basic difference between the parties was their priorities. For the petitioner, the priority was his family, which could be best attended staying at Malbaja. And the opposite party number 2, the priority was for professional life, which could only flourish if she moves to out of Siliguri and goes to a bigger city like Kolkata and something. This was the main reason. Now they have understood that they cannot be together anymore, and they have entered into a settlement and also filed a petition under 13B for the dissolution of their marriage mutually. I have explained the number also in the paragraph number 7. SMAT suit number 128 of 2024. So, my lord, these parties, they genuinely want to end up this misery and they want to start their life afresh here also. And
who is for the opposite de facto company?
It is supposed to be it is being heard for the very first time, Your Lordship. I'll have to if notice is issued, I'll be able to. If a direction of notice be there on by the next Wednesday, I believe that they can. I will get it started because it's in Siliguri. To their council, I can get it.
What is this notarized thing agreement?
Yes.
13B filed already.
Pardon?
13B has been filed.
Yes, my lord. The case number is also there in the paragraph number 7 of my petition, my lord. MAT suit 128 of 2003.
This is an application for washing off. A state is in state to achieve. Proceedings being GR case number 314 of 2023. In connection with Siliguri Women Police Station case number 9 of 2023 under sections 498 capital A / 506 of the Indian Penal Code along with section 4 of Dowry Prohibition Act 1961. Pending before learned. Charge has been framed. Pending before learned. Judicial Magistrate Second Court Siliguri. What is the last order?
Yes, Lordship.
Charge has been framed.
Right. Order dated 15/5 of 2024. Internal page number 3.
On the ground of mutual understanding or settlement, the proceedings under 498 can be quashed in a revisional application.
The answer to this question, my lord.
Yes.
Well, I have a citation. I can give that to your lordship. It's a B.S. Joshi and others versus State of Haryana and others. This is by the decided by the Supreme Court, where such a question arose in a 498A case where there was mutual between the parties. If I may be allowed to place the paragraph number 17. Paragraph number 14.
Okay.
There is no doubt that the object of introducing chapter 20A containing sections 498A in the Indian Penal Code 1860 was to prevent torture to a woman by her husband or by relatives of her husband. Section 498A was added with a view to punishing a husband and his relatives who harass or torture the wife to coerce her or her relatives to satisfy unlawful demands of dowry. The hyper-technical view would be counterproductive and would act against the interests of women and against the object for which the provision was added. There is every likelihood that non-exercise of the inherent power to quash the proceedings to meet the ends of justice would prevent her from settling earlier. That is not the object of the chapter 28 of the Indian Penal Code 1860. And then the court concludes, in view of the above discussion, we hold that the High Court, in exercise of its inherent power, can quash criminal proceedings or fire complaints, and section 320 of the code does not limit or affect the powers under section 482 of the code.
Okay. What is this? 2000?
This is 2003 one. The case name is
2003 volume.
2003 4 Supreme Court cases 675. Equivalent citation, my lord, 2003 SSC SC 396.
2003 volume 4 SCC 675.
Yes, ma'am. Should I give a copy of this?
Not recorded at the time of hearing, please.
As you please.
This is B.N. Joshi versus
B.S. Joshi and others versus State of Haryana and another.
Sure. So learned advocate appearing. ওটা বলো তো?
Chief Landed Judicial Magistrate, Second Court, Jalpaiguri.
So learned advocate appearing for the petitioner submits that the dispute by and between the parties have been amicably settled out of court. An application for divorce on mutual consent under section 13B of the Hindu Marriage Act, being mat suit number
Matsuit number 128 of 2024.
being mat suit number 128 of 2024 has been filed before the learned additional district judge, First Court at Siliguri. ওটাকে কি কোনো ফাইল করলাম না? ফাইল করো, filed and pending before learned additional district judge, First Court at Siliguri for disposal. He seeks to serve copy of this application upon the opposite party number 2. She is the complainant,
Yes, ma'am.
the de facto complainant. In view of such submissions, petitioners are directed to serve copy of this application upon the opposite party number 2 de facto complainant and file affidavit of service on the returnable date. When
Wednesday or Thursday, madam. Next,
is this matter on? Thursday,
as you wish. Much thanks.
30th. No? Thursday is? Thursday কত তারিখ?
Thursday কত করে? 13 January.
Okay, state is there.
1957.
But you secure the attendance of the learned advocate for the de facto complainant. Otherwise, it will not be possible to dispose of the application.
As you wish.
Hmm.
As you lordship.
Their presence has to be there.
They are very much willing to meet. Very fast. Much.
Minor item number 2 and 3 will be taken. These are not 2 and 3. 2 and 3 would be good because both happens to be the counter.
What is CRAN 1 of 2025?
I think that they are willing, that they compromise, that they are willing to withdraw the petition. They have no objection with this. These proceedings are quashed.
They means who?
De facto, the victims.
In 17, you are the petitioner.
Yes, my lord.
I mean, item number 2.
No, yes. Item number 2 is Oshmita Mukherjee is the advocate on record. She is represented by Ms. Tanu Agarwal. And then item number 3, Saptashikar, I am Shubham Chakraborty, I am there.
Both you are withdrawing.
Yes, we have annexed the at brands. All are my lord available and compoundable below 3 years.
Oh,
It's ultimately a case of road risk, my lord, nothing more than that. And there is a 57 days of delay in each FIR.
CRAN 1. Reference. Oh, for quashing of the proceedings.
My lords.
Who is appearing for the de facto complainant in item number 2?
Item number 2, my lord, item number 2 de facto, my lord, I have again. And for item
This is
number
a joint petition.
my lords.
What is the name of the de facto complainant?
In item number 2, my lord,
Yes, what? 2, yes, 2.
is Shubham Chakraborty.
Shubham Chakraborty. And item number 3 is Bikash.
Because yes, who happens to be the petitioner of item number 2.
Okay. State.
My lord, we haven't served it, my lord.
You are representing the state. What is your submission? Give a copy.
Yes, my lord, we'll serve it today, my lord.
You have a copy, hand
Yes.
it over to her. Then it will be again deferred. I will pass over often to ask somebody in the state panel to come. Yes. Ask somebody from the state panel, ask Mr. Chakraborty to assign some other advocate of the panel from the state. Let him come and I will record his submissions. At that time, you give a copy to him.
Well, I don't know, যার direction দিচ্ছি, যাদের উপর কি করে direction দিচ্ছি বলে।
Ask Mr. Chakraborty or any senior counsel of the panel from the state to appear If there is requirement for production of case diary, then I will pass direction. Otherwise, I will hear and dispose of the matter. This is the thing. Right. Yes. 2 and 3 pass over.
Lordship praying for next Saturday.
Why?
Land Council is out of town, some medical emergency.
One, two, alone, Jordan. On the prayer of learned advocate for the petitioner, let the matter appear before the next available circuit.
By rounds of petitioner lordship. Lordship, this is a matter for paying for the first time. And as per my instruction, the parties are seeking to amicably settle the matter between themselves outside the court. If your lordship will grant me some time to settle the matter, then the parties will file an agreement petition or withdraw this petition.
Hmm. So 94 can be compromised.
Lordship, please, lordship. I do not hear that.
494 of IPC, can it be compromised? There is allegation against you.
Parties haven't married any other persons, not the petitioner, not the opposite party. That's a false allegation, which has been leveled against the husband.
Even notice. Ashwin,
Lord, may I seek one kind liberty that to correct the house title, but the 494 section has been wrongly written as 439 of ITC.
okay. This is an application. No, sorry. This criminal revision has been filed for quashing of proceedings being GR case number 1622 of 2024 arising out of Malbajar Police Station case number 185 of 2024 dated 7th April 2024. Under section 498A 109 and 494 of the Indian Penal Code. और ऊपर दिए थे on the prayer of proper on the prayer of learned advocate for the petitioner, leave is granted to correct the relevant provisions of the offense in the cause title as well as in the prayer. Cause title at page 1 and prayer page 9. At page 9 of the petition. Is so and so learned advocate appearing for the petitioner submits that the matter has been amicably settled out of court. Petitioner is directed to serve notice of the petition along with copy of this application upon the in the office of the additional public prosecutor as well as upon opposite party number 2. De facto complainant. File affidavit of service. We're going through de facto complainant through a registered speed post with acknowledgement due and file affidavit of service on the return until date. List this matter before the next available.
Fine. Punch the password letter.
Yeah. দেখি 2 নম্বর 2 আর 3টা দিন তো They say that this is case and counter case and the sections are all compoundable. What is your submission?
Regarding the sections are compoundable, my lord, then.
And be quashed. Can you just check the sections and tell me that those are compoundable because these are the new sections?
I need to.
The DNS and DLS.
You have this?
I don't, I think this is
Auditor causing what my 320 three. And the 11?
nothing kind of just a case.
I need to see whether what was the outcome of the case. So if management can please I will call for it.
The de facto complaint, but needs to, they're willing to quash it. They even the complainant does not willing to proceed with the case. We have annexed the CRAN along with the CR. কিছু ব্যাপারে ড্যামেজ হয়েছে না নিজেদের মধ্যে সর্ট আউট করে নিয়েছে কিন্তু ডিফেক্টিভ তো দাঁড়িয়ে আছে আরেকটা এক্সাক্ট তো হয়েছে না ডিফেক্ট ইজ প্রেজেন্ট উই হ্যাভ গিভেন আওয়ার প্রেজেন্স এই যে তার নিজ ডিফেক্ট আছে পিটিশনার আছে
Yeah. Which is the corresponding section 320 of old CRPC in the Nyaya Samhita?
323 money
320.
320 compounding of offense in 359 value is
It is Bharatiya Nagarik, this one.
Arctic Nagrik Suraksha Salita. But I have the manual. Does manual require the manual?
Yes, it is here. For section 5.
Why it has to be 359.
359. Charge sheet has been filed in this case.
So they are about to file a charge.
One, 115. What is 1151?
What 5-2 is it, my lord?
What is 1?
What we could decipher from the FIR, what they have elaborated in the FIR.
One 1151 is the corresponding to what? Which one?
Whoever doesn't act with an intention of causing hurt to 80% with the knowledge that he is likely to be caused hurt to 80% or thus causes hurt to 80% is said to be voluntarily to cause hurt by the which happens to be, I believe, by not. Two happens to be the period provision of that.
Two. Two is compoundable. Next is. So 1 is not an offense.
No, by
1,
it's a definition clause.
125 PB. Grievous hurt. Grievous hurt, non-compoundable. Yes.
But and the FI also may not have just gone through. I have fell off the bike. I succumbed to injuries on my ankle, resulting in operation and 45 days of complete bed rest. We need to see the injury of this particular person.
Okay. Ask both the petitioners, I mean the de facto complainant of both the cases, to remain present on the returnable date.
My lord,
In the,
can I
yes.
make- yes, but can I
In-
make a request to my lord, my lord? We are getting several calls from the police to come and do this. I believe my lord knows for what they are getting calls. So in the meantime, if a stay could be granted, because. Welcome, Monday. Very well, madam, Monday.
Because it is initial.
Monday, you produce the case diary, huh? And in both the de facto complaint, they have to remain present.
My lord.
And lastly, whether this section grievous hurt is compoundable. It is not compoundable,
Right.
whether this can be compromised and quashing of proceedings order can be passed on compromise.
Very well.
But we have to see whether this person has got compensation or medically, whether the petitioner has given some money for treatment or.
So that
That is up to the
not-
party. That is not the issue. The issue is grievous hurt is not non-compoundable. Whether that can be compromised in a proceedings for quashing.
My lord, wait.
And this is the report of the trial.
So and so learned advocate. You are the petitioner in
Petition three, item number 3,
who is petitioner in 2.
Mr. Noble.
So and so learned advocate appearing for the petitioner submits that the matter has been amicably settled out of court by and between the parties, pursuant to which an application being CRAN 1 of 2025 has been filed. He seeks for quashing of the proceedings. Mr. So and so learned advocate appearing for the state submits that the case diary is required for the hearing of the matter. State is directed to produce the case diary on the returnable date. Learned advocate for the petitioner is directed to serve copy of this application to the in the office of additional public prosecutor, Jalpaiguri. That's it. আরেকটা 3 same order করবেন, same order, so the advocate নামটা পাল্টা 18 AM, same order. Produce the case diary in respect of both the matters. Monday. CG case diary as well as report from I. You have to produce the case diary and the report of the I.
State is directed to produce case diary.
Along with report of the investigating officer. Common 27.
But the only problem is those calls
Which calls?
of the police station. Come, let us see all these calls. My lord knows better what happens.
127.
Very good.
Item number 6 of 7 minutes, the petitioner and the defective complainant were both of them. That in this case, yesterday I have a call with my client, that they are trying to settle the dispute out of court. In this case, I may request your lordship to send the matter to a mediator so that amicably settle about the money.
Settle, then go to the court and settle. Go to the trial court.
Yes, your lordship.
What is the use of mediation?
Mediator, so that they are demanding 40 lakh rupees, I want to, they are opposite de facto complaint, opposite party no demanding 40 lakh rupees. But that is the negotiation is going on. Jalpaiguri mediator, Jalpaiguri, the petition before lordship resident of Assam, and the opposite party by Alipur. The matter can be sent to mediator Jalpaiguri. Within a month, if possible. The maintenance, I have been paying the money that was maintenance was given, I have regularly paid for the deposition on behalf that there is a deposition that she admits that I have been for the proceeding, I have been paying the maintenance.
Which maintenance?
The interim maintenance that was rewarded.
Interim is gone. Interim, the matter has been finally disposed of.
Yes, sir. Subsequently, the execution has been filed. The execution, they have come before lordship for 1 month. Item number 4, item number 7.
7, the item number 7.
Execution, page number 40, case number. Order was passed in December, November, they have come in December on the execution for 1 month. The time of revision is on time of revision now. They have to wait for that time also.
Which time?
The order was passed 29/11/24, the final order of judgment.
The area money 20,000. November 2024.
December they have filed it. Petition.
This is for only 1 month. This is
1
December.
month.
And there is a area.
No, it isn't. I have paid that amount. They have filed this area. They for 1 month.
20,000.
The interim order was initially for 7,000. That was regular pay. Sometimes I have to pay the 10,000. The lordship can send them at a mediator.
No.
They
Dispose of both.
No.
Go to the executing court. Whatever is the fault in the application, that can be decided by the court. No.
May I have minute of the case?
Huh?
Minute of the case.
No merit. For 2 days, I am hearing you. What is your bank manager? What is your profession?
I'm bank official.
Bank official or bank manager?
Kindly come to the item
Wait,
number 6, Miller.
Let me have a look to the
Yeah, Miller.
asset declared by you. What is your name?
Miller. Annex P3 31, Miller. I am the salary is Miller.
Page number?
Page number 31, Miller. P3.
In item number 6.
Yes, Miller. Salary is Miller.
Wait, sir. Senior manager. Senior manager. Gross salary 1,26,000.
Yes, Miller. But I am
Net
getting
salary 38.
38.
No,
Kindly, Miller.
20,000. You know 20,000 nominal.
Miller, kindly, Miller. Otherwise, Miller, we have to settle the dispute. They keep demanding 40 lakhs.
Nobody is stopping you from settling the dispute.
Miller, one thing,
This
Miller.
revision cannot be
One thing-
kept pending, sir.
One thing, Miller. She kindly come to the Annex P2, page 31. Miller, kindly see her educational quality.
T2.
Yes, Miller. She is not a normal lady, Miller. How she, Miller, it took highly educated. And Miller, kindly see her expenses. 1 lakh.
T2 of
Miller, P2 page 31. Miller, even a highly post for the Miller, highly Miller, she will have the capacity to spend 1 lakh rupees per month. She, Miller,
MA.
Miller, highly qualified. And the expenses kindly similar. 7. 1 lakh rupees. Para 7. All are non-applicable, only the expenses is 1 lakh rupees.
Hmm.
Well-bodied Miller, well highly educated Miller, she have the capacity to earn Miller. She fits herself to claim on the
57,000. Any revision filed before the district judge
no, Miller, I have come before the first time.
from the judicial magistrate's order to this
High
court?
court. Concurrent jurisdiction Miller.
Okay. This criminal revision is filed challenging filed against the judgment and order dated 29th November 2024 passed by learned judicial magistrate first court Alipurdwar in MR case number 166 of 2021 under section 125 of the Criminal Procedure Code 1973 within bracket যখন করবেন italics এ করবেন hereinafter referred to as the code bracket close para. The brief fact of the case is that the petitioner the marriage The marriage between the petitioner and opposite party number 2 was solemnized on 25th January 2019 as per Hindu rites and customs. Any child is here? No.
No, not that. First, now we get to the other.
And- And their marriage was duly consumed. On the 25th January of
2019 as per the Hindu marriage.
in the during their matrimonial life, dispute cropped up. And date of living separately, and dispute cropped up.
16 June 2021, paragraph 14.
16 June 26.
Paragraph
Was
14, paragraph 14.
No. 16 June is they together they went for Jamai Sosti.
The Kandika paragraph 14, look. 16 June 21, petitioner is residing in her father's house under the charity of her pension holder father. Page 14, paragraph 14.
Wait. It is contained in the petition under section 125 of the code that since 16 June 2021, the opposite party number 1 left her in her father's house. Left her in her father's house. The petitioner, the opposite party number 2 filed an application under section 125 of the code for maintenance. Upon considering the materials on record and the evidence produced, the learned judicial magistrate Vide order dated, judgment and order dated 29th November 2024, granted maintenance allowance to the tune of rupees 20,000 per month in favor of opposite party number 2 from the date of filing of the maintenance petition, that is 7th July 2021, and also directed for payment of arrears from July 2021 to November 2024. Being agreed by the said order, the petitioner has preferred the present revision. Stop. Mr. Orijit Ghosh, learned advocate appearing for the petitioner, submits that the opposite party number 2 is a highly demanding lady and used to pressurize the petitioner for costly gifts and ornaments, which will be evident from her affidavit, annexure T2, page 21, wherein the general monthly expenses has been disclosed as 1 lakh.
No, this is the affidavit, not my opposition. This is how affidavit. Opposite party-
এবারে affidavit তো বলছে, এবার কি? Affidavit.
Do it made by the opposite party number 2.
I should. হ্যাঁ, আপনি একটু দাঁড়ান একটু, হ্যাঁ, ওর সাবমিশনটা নোট করে নিন, ওকে, নাহলে আবার হাফ ডান হয়ে যাবে। He also submits that the opposite party number 2 is highly qualified so therefore such aspects has to be taken into consideration while deciding the quantum of maintenance.
May I add on?
He seeks
No, she can earn himself.
and she can earn her own livelihood. ওইটাতে দিন, ওই সেন্টেন্সে কমপ্লিট যে highly educated and she can earn her own livelihood. Stop. Therefore, the maintenance of rupees 20,000 per month granted by the learned judicial magistrate is excessive and requires to be modified. Upon going through the judgment of the learned trial court, it is found that admittedly, the monthly salary of the petitioner is rupees 57,000. The learned trial judge, upon consideration of the evidence, has held that the petitioner husband has sufficient means to maintain her. There is nothing on material to show that the petitioner husband provided maintenance to the wife after living separately. To economically support her.
This is the wrong.
This is
Recording, this is the Miller. He on her, because she said all her, she was receiving also of the Miller. I can show the deposition. The kind
Chalo.
of, kind do not record the Miller. Your lordship kindly see Miller, the deposition of
the
deposition. The you are saying Miller all that she was that from 10th line from bottom Miller, 10th line from bottom Miller. It was in bracket because she was receiving. This was the wrong document.
full lines from
Page line from bottom. But just the bracket, there was a small bracket.
DOS.
There's a bracket, small bracket.
Increment given by the order of the court.
Yes, sir.
That is what.
Something I have paying here.
Apart from interim maintenance, which has been ordered by the trial court. It is also found that the trial court has taken into consideration the standard of living of the parties as well as the market value of the essential commodities. Bearing in mind the aforesaid, this court does not find any illegality or infirmity in the order passed by the learned trial judge. In view of the above, the criminal revision being CRR 22 of 2025 stands dismissed. All connected applications.
The order was given the 29th September. The order may be passed, that 20,000 may be given from that date. The from initially have been paying that amount.
No,
That's not the
no way. It according to and it is really pertinent to note that the petitioner is chief manager of UCO Bank. UCO Bank. UCO Bank. Chief Manager, Senior Manager, UCO Bank. इसमें CRR 26 of 2025. Oh, this. Which order has been challenged?
The entire process I have challenged, sir.
This criminal division has been filed challenging the proceedings being MR execution case number 167 of 2024. In connection with judgment and order dated 29th November 2024, passed in MR case number 166 of 2021. CRPC রে দিন তো। Whole or any part of each month's. No. One month cannot be claimed. What is your submission?
Lord, I have referred the application that the order was for 29th November. Now the revisional period before the High Court Millard is 3 months. So that comes out around Millard February. And within Millard, before expiry of 3 months, Millard, they have come before the execution case.
No, where is that provision that the 1 month's maintenance cannot be put into execution?
I have come under the
This is not a 125(3) says that either the whole or month's allowance. And that application should be filed within a period of 1 year. Not up beyond that. You cannot file execution case of a matter which is more than 1 year. You have to come up within 1 year. 1 month, 2 months, whatever is the unpaid, that should be within 1 year the application has to be filed. That is what 3 says. Korun.
From the state of order.
The only relief I can give is withdraw this application and challenge it before that.
Yes, Your Lordship.
Or else you contest whatever the settlement, you go and contest it
Your
before the trial
Lordship,
court.
I can allow me withdraw, then I can withdraw.
After making submissions, now you get.
Fine.
No.
Kindly. Lord, you kindly give the rebut in. Kindly, Lord. He is also, Lord, both are trying to settle.
No.
Lord, kindly.
Lord,
kindly.
division.
Lord, kindly,
Huh?
because your Lordship has
No.
expressed your mind. Lord, kindly, because your Lordship expressed your mind, Lordship.
Challenging the proceeding in the case number 77 international judgment and order dated.
With this. Mr. Orijit Ghosh, learned advocate for the petitioner, submits that the execution case has been filed for recovery of allowance of only 1 month. And as such, the application for execution itself is not maintainable. In order to appreciate the aforesaid issue, it would be apposite to reproduce the relevant provisions of 125 of the code as hereunder. 125(3) টা করুন, হ্যাঁ? এখানে provided এই জায়গাটা দাগ দিয়ে দিলাম। 3 টা পুরোটা করবে, 3 টা।
125(3).
Upon bare reading of the aforesaid provision, it manifests that there is no such embargo in claiming maintenance of an unpaid amount for a single month. Thus, the argument advanced on behalf of the petitioner falls short of merit. In view of the above, CRR, the criminal revision being CRR 26 of 2025 stands dismissed. All connected application has to suffer. You will make payment.
At least one degree from the date of passing the order, that will happen. Actually,
Sorry, Mr. Ghosh. Okay, thank you. Eight. ও এই কালকে চলে গেছিল, কোথায় গেল? সৌম্যজিৎ কি নাম হয়েছে? সৌম্যজিৎ জিজ্ঞেস করতে হবে, সৌম্যজিৎ। I'm making it pass over. Ask him to come. Yesterday onwards, he is taking adjournment, seeking passovers, and then not coming before the court. Yesterday, he said that 5 minutes time, I will take instruction from my senior and move the application. I waited for him till 1:15, he didn't turn up. একটু passover রাখুন যদি পাওয়া যায়। Next.
Lordship, the motion states.
Yes.
I came to this honorable court in respect of the registration of GR case in connection with the Siliguri Women PS under section 498A, 406, 313, 506, and 376 of Indian Penal. Here the petitioners all are the in-laws, distant in-laws of the opposite party number 2, Lordship. Lordship, kindly referring the written complaint as lodged by the de facto complainant, that is the OP number
What do
2
you
before the
do?
concerned authority, police authority, dated.
You copy pasted. What is your case number? Withdraw this application.
Lordship,
Withdraw this petition.
my number is serial number 228 of 2025.
28.
28 of 2025.
And what is the case number?
Case number that is
Siliguri Women Police.
yes, Lordship.
GR case number 1717.
Yes, 1717.
Then your prayer. From grounds to prayer, this has been, I think, copied from some other petition. You have sought for quashing of which case? 425/2024, which is GR case number 2293 of 2024. Withdraw this application.
Lordship, liberty may be given.
Mr. So-and-so learned advocate for the petitioner submits that inadvertent typographical error has crept into the prayer portion of the application. He seeks to withdraw the application with liberty to file afresh. In view of such submissions, the CRR, the criminal revision being CRR 28 of 2025 stands dismissed as withdrawn with liberty to file afresh.
Did the operation.
This is a new motion application, my lord. My lord, in this petition, I praying for the quashing of GR case number. My lord, 1921 of 2024, culminating of a FIR 351, where my lord, the opposite party number 2 alleged the case under section 417, 376, and 313. My lord, now the opposite party number 2 and the petitioner, my lord, are as a living as a husband and wife, my lord. Kindly see, my lord, annexure P1, my lord.
Charge sheet submitted.
Charge sheet has already been submitted, my lord. They have been residing together from since 2014, my lord. And my lord, they have a baby girl, my lord. Now, my lord, they both wanted to quashing them.
Yes. This can be quashed.
My lord, annexure P1 is a marriage registration. And my lord, annexure P2 is a birth certificate of the my lord, daughter of petitioner and opposite party number 2.
This cannot be quashed. 376 method. Go before the trial court, whatever you have to say. What is the stage of the trial?
My lord, only charge sheet has submitted, case is not submitted yet.
No.
let there be interim statement of the opposite. The state is filed, because in another, in similar cases, where there is a, both party filed joint compromise application and subsequently matter was quashed by the honorable court.
Which court?
The honorable high court, in case of non-compoundable offences. Both the petitioner and the opposite party number 2 filed an application for joint compromise application and subsequently.
There is a category which has been given in the judgment of the Honorable Supreme Court where non-compoundable offences can be compromised. But there are also certain limitation to that. If it is an offense of a heinous offense, can it be compromised?
It is not a heinous offense. Kindly see the FIR once. There is a general omnibus allegation.
You have gone through the judgment of the Honorable
Honorable
Supreme Court. Now go through that. Offences relating to moral turpitude cannot be compromised. But non-compoundable offences which can be compromised can be quashed by way of a proceedings. So the only recourse left to is framing of charge, going for the evidence. It can be quashed in this proceeding.
by submitting to that, they are deciding to give a matter.
I have understood your circumstances. Now you have a family. Correct? But on the date the offense took place, you have to go back to that. On that date, the offense was there. And this is an offense under 376. How can this be compromised? This is the question.
In similar circumstances, your lordship directed, let there be direction upon the state to record the statement of the victim girl. And if the victim girl is deposed in my favor, then if your lordship kindly allow.
Then also it cannot be allowed. You are not understanding. This is 376.
Kindly see, this is the case of 2014. This is the 24.
Trying to establish that or is that. After all, this is
Case of acquittal.
policy as per proceeding.
Why you are coming in a revision for quashing of the proceedings? Expedite the trial before the court. Appear before that. Request the court to frame charge and proceed. But it cannot be exercised in a case where there is a 376 allegation of 376.
Let there be a. What happened in the last month due to my non-appearance, warrant has been issued against me now by the learned trial court. Not my lord trial court, by the learned CGM Jalpaiguri. Then my lord kindly stay the warrant. I will appear before the learned trial. The impugned order is page 16. On page 16 is under the envelope because it is a POXO case. I have to.
Oh, wait.
POXO.
Foxo.
376.
At the time of incident,
He is 19 years.
You were on bail.
On 2015, I am on bail. Subsequently, in the 12th of December 2024, due to my non-appearance, my lord, the learned CJM issued warrant of arrest against me, my lord.
Go and surrender.
Only due to non-appearance, my lord. Kindly see, without following the proper step, the learned chief judicial magistrate has been issued warrant of arrest against me, my lord. Because, my lord, in the ordinary course, there is a first direction upon the surety to produce the accused person. If they are failed to produce, then, my lord, warrant of arrest has been issued against me. Without, my lord, following that procedure, warrant of arrest has been issued against me, my lord. And learned CGM Jalpaiguri, my lord, also started the proceedings of 446 against those surety, my lord, without giving any opportunity to them.
When was the warrant of arrest issued?
12th of August 2020, 12th of December 2021, last month.
Charge sheet submitted.
Charge sheet submitted. In the year,
When was the charge sheet submitted?
in the year 2019, Bharat, after 5 years of the Bharat initiation of the FIR. Page 19 is the charge sheet. But from 2015, Bharat,
Why are you pursuing such applications wherein the relief cannot be granted? Why the accused person is not appearing before the court to have a expeditious trial of the
Bharat, I was
Proceedings.
appear before the each and every day, Bharat. Only on the last occasion, due to my non-appearance, this has been happened, Bharat.
only one day?
Bharat, so far my instruction, because I have
Your
already
instruction is incorrect.
Then Bharat, kindly fix
You
the
have to
matter,
issue
because the
warrant
next
of
week
arrest.
I will come with the instruction.
Who is for the state?
Bharat.
376, 330. Quashing.
Yes.
Come with the instruction.
I have said no.
No, 376 cannot be. That is what I'm asking you. Go before the trial court, expedite the trial.
At
best, they can, at best, they will come with an affidavit, my lord, even that also will
They
not.
cannot be considered. That is what I have told them.
Let them go to the trial court, let the witness be called and.
If your lordship there, we can also file a joint compromise application with an evidence.
No, I am not directing you.
Fine.
Then I will dismiss this
No,
petition.
Next week. I will
What
follow
next week?
instruction as your lordship direct.
You produce the case diary.
Then they have to give their copy of when I will send. My appointment may be regular, otherwise.
This criminal division has been filed for quashing of proceedings, being GR case number 1921 of 2014. In connection with Kotwali Police Station case number 351 of 2014, dated 23rd April 2014, under section 417, 376, 313 of the Indian Penal Code. And for quashing of issuance of quashing of the order dated 12 December 2024 of issuing warrant of arrest against the petitioner. Petitioner is directed to. Oh, it is Mr. So-and-so, learned advocate for the petitioner. Petitioner, learned advocate, Mr. So-and-so, learned advocate petitioner submits that the matter has been settled amicably out of course. Mr. So also learned advocate appearing for the de facto complainant, victim. Victim is the complainant.
My lord, victim is the complainant.
Right? Concedes to the same. Sorry, amicable now. They have been married and leading their marital life, not amicably settled,
Have been married.
and leading their marital life. Mr. Niloy Chakraborty, who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. Chakraborty be regularized by the concerned department.
Yes.
State is directed to produce the case. He submits that the nature of offense being non-compoundable cannot be compromised and quashed, and the proceedings cannot be quashed as prayed for. State is directed to produce the case diary on the returnable date. When Mr. Chakraborty, when can this be produced?
Monday.
And also give a status report. I think it cannot be committed because he is not going to the trial court to have it committed. Warrant of arrest is pending against him.
Oh.
This is what I gather from the produce the case diary.
29th, my lord.
29th.
My lord.
देखो 29th है 29th.
Until then, there will stay, my lord.
No.
My lord, because my lord, if
See a misconceived application. Now today only I could have dismissed this application. The recourse left to you is to expedite the trial.
Right, to brief them at case number 3.
kindly there is a stay, my lord, because in the meantime, if I am arrested, my lord.
তাহলে ফ্রাইডে রেখে দিচ্ছি if you want.
My lord, kindly, leave it as stay, my lord, for 2 days or 3 days.
No stay.
Yes.
তাড়াতাড়ি করো, শেষ হয়ে যাবে।
What is in the item number 9, that application has been not pressed.
Just
Before, the certified copies, all the original certified copies are. lying
Liberty is 9 আপনি নিয়েছেন?
আরে পরে রেখে দিচ্ছি।
Liberty on the prayer of learned advocate for the petitioner, liberty is granted to withdraw the certified copies of the orders.
Not order, FIR, complaint and charge sheet.
Liberty is granted to withdraw the certified
All the
copy of
original certified copies as annexed to
certified copies of the
as annexed to the application.
certified copies and of the orders and orders annexed to the petition.
Or FIR complaint order is not there.
FIR, certified copies of FIR, complaint
And charge sheet.
and charge sheet.
If any other order. Lordship, deep.
কবে থেকে আসছে গো? এটা মার্ক করছেন না কেন? 21 তারিখ ছিল ওটা লিস্টে?
লিস্টে ছিল, আর আজকের যেটা হবে আজকে মার্ক করে দেব।
None appears on behalf of the none appears on behalf of the petitioner. The state is represented. Achha, none appears on behalf of the petitioner, nor any accommodation has been sought for. State is represented. কি চেয়েছে? The application is presented. In view of the above, the application for restoration being can 1 of 2024, as well as the application for condonation of delay being can 2 of 2024 stands dismissed for default. Interim orders, if any, stand vacated.
I am for the petitioner. In this case, complainant has withdrawn this complaint case. There is the case number CR 385 of 2020, in respect of which quashing of proceeding has been sought before this honorable court. Yesterday, learned advocate Punanjit Bhattacharjee sought for necessary order regarding this withdrawn. And today I am producing the order of withdrawn before this honorable court.
This criminal revision has been filed for quashing of proceedings being CR case number 385 of 2020 under section 500/34 of the Indian Penal Code. Mr. Swensu, learned advocate for the petitioner, submits that the complainant has already withdrawn the complaint case before the trial court. আচ্ছা ওই পেন্ডিং বিফোর লার্নের জুডিশিয়াল ম্যাজিস্ট্রেট ফার্স্ট কোর্ট শিলিগুড়ি ওই যে কশিং এর যে কোর্টটা পেন্ডিং বিফোর জুডিশিয়াল ম্যাজিস্ট্রেট ফার্স্ট কোর্ট শিলিগুড়ি he seeks to withdraw this criminal revision. He files copy of the order dated 9/12/2024 passed in CR case number 385 of 2020 by the trial judge, which is taken on record. Para. Upon perusal of the order of the trial judge, above order of the trial judge, it is found that the complainant filed an application under section 257 of the Criminal Procedure Code for withdrawal of the case, which has been allowed by the trial judge. Stop. In view of submissions made on behalf of the petitioner, the present criminal revision being CRR 56 of 2021 stands dismissed as withdrawn. Interim orders, if any, stands vacated. All connected applications stands disposed of. Urgent photostat. Certified copy. Hmm.
Lord, Lord, I am appearing on behalf of the petitions matter along with my learned juniors. Lord, I am addressing a lawsuit court from Calcutta. Lord, I am audible, I think
Yes,
so.
yes.
Lord, and we have been missing him for a long time, Lord, here in Calcutta.
Yes.
Lord, what has actually happened? Lord, I filed an application for quashing of the criminal proceedings. Lord, and Lord, the allegations was under section 406, 420. The matter was heard on 7th of August 2023. Lord, by His Lordship Honorable Justice Vishnu Chaudhary, and His Lordship's pleasure was to give the interim order. Lord, having gone through all the materials on record, this is purely a case of civil nature. Lord, what has actually happened? That the defective complainant, Lord, he transferred a particular plot of land, Lord, with the permission of the authorities, Lord, the subdivision officer Darjeeling. For that, if any plot is auctioned, a notice is given. Notice was widely circulated, and there was no objection. My client deposited the entire amount. Not that his name was also recorded. Everything happened. Then, out of provocation by one of his relations, Lord, he filed the a criminal case under 406, 420. Lord, having gone through the order, the case, Lord, His Lordship Honorable Justice Vishnu Chaudhary found that this is purely a case of the civil nature, and no criminal proceedings lies. However, interim order was granted. The opposite parties entered appearance. But they took time for filing the affidavit, Lord. And affidavit was filed, Lord. My learned junior, one of my learned juniors is there, Lord. They have given, Lord, the affidavit. If Your Lordship kindly sees the affidavit, the nature of the affidavit, Lord. That is the affidavit in opposition filed by the Lord, the defective complainant. For the first time, I'm seeing, see the cause title only. Cause title of the affidavit, Your Lordship will see that it is an application under Article 227 of the Constitution of India. In such a slipshod manner, the affidavit in opposition has been used. And I have found for the first time that the learned lawyer for whom I have due respect, without looking into the papers, he has filed this affidavit in opposition, putting that this is an application under Article 227, etc. Where there was an order upon him, Lord, to file some additional documents. I have filed one supplementary affidavit. That too, they have not replied. Lord, now the position is this, Lord, my client has filed also issued for declaration. That is pending. We are enjoying the interim order. They have entered appearance. They have not filed any suit. And in this way, the matter is being dragged on. I am in position. There is no problem in that. These are my humble submissions, Lord. This application, the supplementary affidavit, the affidavit in opposition which they have filed, that should be not rejected, or let be given a chance to file a further affidavit. Because this affidavit cannot do. He says that this is an application under Article 227. In the midst of the application, I found that already it is stated that this is the application to 227, this and that. And unnecessarily the matter is being dragged on, and I am being harassed. I have purchased the property. There is no denial, nothing. And my name has already been mutated. The authorities concerned, the government, this is a government's land. Government has auctioned the property. I have purchased the property. Money has been deposited. My name has been mutated. Everything has been done. Then, out of provocation by one of his relations, filed a case. And 420 and 406 case that can be imposed, or it can be filed just to drag the matter. When there is a civil dispute, the case is of civil nature. Land has been, my client's name has been already mutated. Everything has happened. And in this way, the matter is being dragged on. I do not know whether anybody is appearing on behalf of the defective complaint before a lawsuit or not.
Yes. That is all?
See the affidavit in opposition.
Yes.
It's a wonderful thing. For the first time, I have seen it.
Yes.
But my humble submission before lordship is just not the lordship, allow my application set aside, my lord, that order the cost that, my lord, proceedings, because there is no use keeping the matter pending. Because the civil suit is pending, injunction is being enjoyed by me. There is no problem. They have not entered appearance. They have not filed any written statement, no written objection also, nothing of the sort till date.
Now, this suit was filed by whom?
My lord, the suit was filed by me after this blood. I filed a suit for declaration, and I have got the injunction also. That injunction is pending, and they have entered appearance. They have not filed any written statement. Neither they have taken any steps to get the interim order vacated. Also, your lordship has wide experience. My lord, they ought to have filed an application for vacating the interim order. That they have not done. Nothing. And in this way, the matter is being dragged on.
And what is your submission with regard to the
criminal revision, Lord? Lord, my humble submission before lordship.
With regard to page 72 of your application?
Page 72 of my criminal revision application.
Yes.
Just also can I get some minutes? Page 70. Yes. This is the title suit is pending. The title suit is pending. One mistake was there, not a bona fide mistake took place. That was also corrected. We have filed one supplementary affidavit. Also, copy has also been served. We have filed a supplementary copy of the supplementary affidavit has also been given. That is on the record. That is already on the record. We have got
this is a wrong document. This is a wrong document. We have already filed the suit. We have been enjoying the interim order. That is correct. But this plaint that has been filed is not the original plaint.
The original plaint. The copy of the original plaint is with me. That is what I tell your lordship. We have filed one supplementary affidavit. Lordship, can you say that one supplementary affidavit? Lordships, on your lordship's record, this copy of the supplementary affidavit. I am putting this question to myself. So supplementary affidavit lordship, can you take up? Supplementary affidavit of mine.
You have filed a supplementary.
Yes, I have filed a supplementary affidavit. Lordship, can you see? Supplementary affidavit. The leave was granted by the on the court blood. The copy of the supplementary affidavit is there. Copy has been served upon them. And there is no reply of the supplementary affidavit, nothing denial, nothing. And in their affidavit on opposition, it is a vague denial. And they have also filed
when did you file the supplementary affidavit?
The date of paper 14th of December 2023. It appears
14th December 23.
December 2023. Yes, it is duly stamped, and they have also filed one suit, Lord. Lord, the de facto complaint has also filed one. The title suit number 9 of. আমাদের জুনিয়র আছে ওইখানে।
In the supplementary affidavit, you have not stated that there was an inadvertent mistake in annexing page 72 of the plaint, which is not the original copy.
May humbly submit before lawsuit. There was a bona fide mistake, but the thing is, in their objection, we filed one application for compliance. In that, they have filed one objection, and this Gopal Das has signed all the papers. Lordship knows that, that under Order 1 Rule 10(2), Lordship has wide experience. The court can add or court can subject the name, and they have entered appearance. It is not that the Gopal Das has not entered appearance in the matter. He has entered appearance in the matter, and he has filed the affidavit also. All the signatories, the defendants are there, the
No,
signatories. From that, it does not matter whether that the name has been advertently left or not, but he has entered appearance, he has filed the application also, that has also bears the signature of that Gopal Das. And Gopal Das has also filed a title suit number 9 of 2023. Now pending in the court of the learned senior division at Siliguri. In that suit, he has got no injunction, nothing of the sort. It is just making the matter complicated.
no. On 29th November 2023,
My lord.
the order was passed. It was recorded in the order that learned advocate for opposite party.
Order is with me.
Yes,
The
learned
order is
advocate
with me,
for opposite
29th
party number 2
Yes.
indicated that the page in 72 is not the original plaint which has been filed in court. After
Lord,
that,
it is
adjournment
their
was
allegation.
sought for. Adjournment was sought for. You sought for
Yes.
time to file supplementary affidavit.
Yes, supplementary affidavit has
Now
been
you
filed.
come to your supplementary affidavit. Did you
Supplementary,
state?
Lord, I have gone through the supplementary affidavit.
Yes.
Lordship,
Have you
but very
stated
minor,
in
I
your
have gone the
supplementary affidavit that this was an inadvertent mistake on your part in
Lord,
accepting a separate petition?
it was an inadvertent mistake, Lord. It was not done deliberately, but afterwards that Gopal
Where
Das
is that?
entered appearance along with others.
Where have you stated
Lord,
that?
That Lordship, kindly give me a minute's time, Lord. Following documents, copy of the plaint sent to the, but copy of the plaint connection. Lordship will kindly page paragraph 3, your Lordship. It is a page 17 connection of the title. Page 17, paragraph 3, your Lordship has got that of my supplementary affidavit. There the petition says that in course of the such and such a photocopy of the said I am not there. That in course of the said hearing of the criminal revision application, Lordship Honorable Judge Mukherjee was pleased to record the submission of the opposite party number 2, which is learned counsel appearing on behalf of the opposite party number 2 submits that the copy of the plaint annexed by the petition page number 72 in connection with title suit number 36. There is no dispute with regard to the title suit pending before the court number such and such related to the present dispute does not match with the copy of the plaint sent to the other defendants. But that is the subject matter of scrutiny by the court. But we have already sent the copies. Yes, that there was mistake. I do admit that there was inadvertent mistake. That is that cannot be denied. I cannot say that that there is no mistake. There was inadvertent mistake, and thereafter, we have annexed all the papers, also the documents which were required. And what the Gopal Das has entered appearance, if your Lordship kindly sees that one copy I am showing your Lordship, where he has put the signature on the objections to our order 39 rule 2A. He has filed the objection where the name of Gopal Das appears as cell number 1 at all, and in the bill also. But everywhere he has entered appearance. Suppose his name has been inadvertently left. When he has entered appearance, that waves. When he has entered appearance, he has not raised objection at that time, particular point of time, or there was an inadvertent mistake on the part of the learned advocate. For the mistake of the learned advocate, the client would not suffer, and thereafter another proceedings and another cause of action that arises, and the papers have been filed by the defendants. You are putting your signature. It goes itself to show that yes, you had the knowledge and you are appearing everything. You are fully aware. It is not the thing that you are not aware. Just a minute.
And this is
and you have filed. Yes.
You come to page 74.
Page 74 of my revision application. Of my revision
And
application.
also take
just a minute. 73, 74.
74, and also take
page
number 9 of the affidavit in opposition filed by opposite party number 2.
Just a minute, Lordship, affidavit in opposition. Yes, page 9. Lordship has seen the first title of the affidavit. Lord, I am putting this question to myself. Your Lordship has seen the first title of the affidavit. Just a minute. This is not the application under Article 227. This is not the application under Article 227.
Anyway,
this is the
they have annexed the original plaint, right?
they have added the original print that I have seen.
No.
Just page 9, page number 9. Yes. No, just let me see. They have annexed the original print. Yes. Number 1 is Pradeep Biswas. That I have seen. Lord.
Okay.
Lord, I do
Para
say,
one.
Lord, there was
You
Lord,
just take page 74 of your petition and also side by side, you keep page 9 open.
yes.
Now, para
Yes.
1 of your plaint, which you have annexed, it reads that defendant number 1, namely Gopal Biswas.
My Lord.
Whereas the original plaint that has been annexed to the opposition reads as that one Sri Gopal Biswas. So it is not the fact that only in the cause title there is a mistake, typographical mistake. The averment in the plaint also is different. However, there is no such endeavor on the part of your client to state in the supplementary affidavit admitting this fact that this is not the original. Inadvertently, a typed copy has been annexed to the petition.
To be very candid with your lordship, I should make a very candid submission. I have very minutely gone through it, and I found that there is some mistake in drafting also. I do not put the blame upon the learned advocate because the client's lordship knows. But he ought to have said that yes, there was some inadvertent mistake, Lord. That is there. I do admit. Lord, I cannot deny the fact. Since your lordship has found, but in my petition, I have said defendant number 1. They were under the Lord presumption that a defendant number 1 is there, the print is there. But there was some mistake. I do admit. That is the reason the leave was granted. Lord, a petition supplementary affidavit was filed also. If your lordship show wishes, I can ask my learned junior to file one further supplementary affidavit stating all the facts. Because that is subject to lordship pleasure. But the thing is,
two things are to be there. One is that there is an inadvertent mistake on your part in annexing the plaint.
Lordship kindly record.
Second is that the copy of the original plaint annexed to the opposition, you admit that this is original, or you annex in your supplementary affidavit, which is the original plaint.
Lordship, I'm much obliged to Lordship. Lordship, kindly pass that order. I'm much obliged to Lordship. Because for a lawyer's mistake, Lord, the client should not suffer. Your Lordship has wide experience. For a lawyer's mistake in drafting the plaint or the petition or the written statement, when there is an inadvertent mistake or some negligence on the part of the lawyer, the client should not suffer for that. The ends of justice says so. Your Lordship knows.
Yes.
Already this matter has been considered in the same fashion earlier. This submission came before this house. Thereafter, again the liberty with the very wide thinking that the liberty has been granted. Thereafter, what came before the court? As because there is no material will come again and again. If again and again the opportunity will be given to the petition. As because the original plaint which has been obtained with the way of the certified copy from the Islamic court, then it will come again. Either I will produce it, or the petitioner will produce it. Matter will be same. And the thing is that only the defense has been taken by the petitioner that the matter is civil in nature. Matter is civil in nature, maybe it's in between other parties. But in respect of this particular complaint, copy number 2 has lodged the complaint. Please see the complaint which has been annexed.
This is for the state. CD is there.
It is already in the record. Hearing has already been gone. Only the opportunity has been given to repair the irregularity. But how the repair will be removed? Itself the claim that there is no such suit is pending against this opposite party number 2. How it will be propped up? So the entire whatever the fee has been taken by the petitioner in this particular quashing application, it will not make any sense. Please coming to the page number 101.
What is your name? I mean your client's name.
My client's name is the opposite party number 2, Gopal Biswas.
Okay.
Lordship, please coming to the page number 101. of the original application, that is the written complaint. At the same time, court will go into the merit of that FIR, contents of the FIR itself. And after investigation, charge sheet has already been submitted by the investigating officer.
Okay.
So is the agent about 90 years? Why will he go to the police station and lodge the first complaint?
Now, what is the contents and this complaint?
Contents, charge sheet is, should I read?
Yes.
From the second paragraph, Lordship. উল্লিখিত ঠিকানায় নিম্ন তালিকা সাচান সাচ খতিয়ান নাম্বার এত ডেসিমেল জমি রয়েছে, জমিতে তৈরি করা দুটি দোকান বড় আমার মেয়ের ঘরের নাতি শ্রী রাহুল দাস ও মমতা দাসকে তাদের সুন্দর ভবিষ্যৎ কামনায় দিই। এখানে উল্লিখিত যে উক্ত দোকান ঘরের মধ্যে প্রথম দোকান ঘরটি তৈরির যাবতীয় খরচা বড় নাতি শ্রী রাহুল দাস বহন করে। পরবর্তী সময় বয়সজনিত কারণে ও অতিমারী পরিস্থিতির জন্য নিজে রেজিস্ট্রি প্রক্রিয়া সম্পাদন করতে না পারলে ছোট নাতি শ্রী মনোজ দাসকে, হিয়ার ইজ দ্য পিটিশনার, মনোজ দাসকে রেজিস্ট্রি প্রক্রিয়া সম্পাদন করার দায়িত্ব দিই। এর পরবর্তী সময় কিছুটা আমার
This is Daitodi, or that the power of attorney is here.
পরবর্তী সময় কিছুটা আমার বয়সজনিত কারণে ও কোনো কিছু না দেখে না জেনে এবং ছোট নাতি শ্রী মনোজ দাসের উপর বিশ্বাস করে আমি কিছু কাগজে সই করি। পরবর্তী সময় আমি জানতে পারি যে আমার ছোট নাতি শ্রী মনোজ দাসের এবং উদ্দেশ্য দুটি দোকানই নিজের নামে রেজিস্ট্রি করে নেয়। ডিড নাম্বার সাচ এন্ড সাচ, পাওয়ার অফ অ্যাটর্নি দেওয়া হলো, নিজের নাম থেকে রেজিস্ট্রি করে নেবে। দেয়ার আর সো মেনি অ্যালিগেশন। তারপরে থার্ড প্যারাগ্রাফ, লর্ডশিপ প্লিজ। আমি আরো জানতে পারলাম যে আমাকে দিয়ে আমার সম্পত্তির একটি উইল তৈরি করা হয়েছে, যাহা আমার অবর্তমানে আমার সন্তানের মধ্যে বিলি বন্টনের বিষয়, যেখানে আমার অন্যান্য সন্তানদের বঞ্চিত করা আমার কন্যা মনোজ দাসের মায়ের নামে বেশিরভাগ সম্পত্তি লিখিয়ে নেওয়া হয়েছে। এরকম কোনো উইল আমাকে না জানিয়ে আমার বার্ধক্যের সুযোগ নিয়ে আমার সম্পত্তি আত্মসাৎ করার উদ্দেশ্যে শ্রী মনোজ দাস আমাকে না জানিয়ে মিথ্যা কথা বলে কোথায় সাবমিশন সিরিয়াস অ্যালিগেশনস আর দেয়ার। This should be scrutinized by the trial court. Charge sheet has already been submitted. Only the plea has been taken that the matter is civil in nature. One suit is pending. Only on that ground, this
Two suits are pending, Lord. But I'm sorry to interrupt, my learned friend. Two suits are pending. Two suits are pending.
There is no any injunction order. Order.
You have also filed a suit.
That is a different matter. Different suit is there. Yes.
Not against this grandson.
No, nothing. They have not taken any steps Lord, to get the injunction vacated. Moreover, we have filed one RTI application also. If my learned friends wants to go in detail, then I shall invite your lordship's attention, Lord, to P2 page 25 of my criminal revision application. Because a notice has been issued by the Assistant Tahsildar. A public notice has been issued. Lord, I'm reading it. Notice is hereby issued to the information of general public that Sri Gopal Biswas of such and such prayed for sale permission of land out of DI fund such and such, measuring such and such.
So you will get your chance to reply. I will come back.
Yes, my lord, my lord.
Let us have.
Then, when the opportunity has been given to the petitioner for rectifying this particular, what was the order? Please, Lordship, referring the order dated 29/11/2023.
29, where it is?
Order has passed in this particular application.
Oh.
29/11/2023.
Yes.
Case diary is being produced on behalf of the prosecution agency. It is submitted that the IO has now been transferred and such and such. Accordingly, the personal appearance of the IO is dispensed. Learned counsel appearing on behalf of the opposite party number 2 submits the copy of the plaint annexed by the petitioner number 2, page number 72, connected with the title suit number 142, such and such. Learned civil junior petition, Jalpaiguri related to present dispute does not match with the copy of the plaint sent to the other defendants. Moreover, the same name of Gopal Vishar, that is opposite party number 2, herein is not appearing in the copy of the plaint sent to the other defendant, but in the copy of the plaint annexed with the plaint, he has been shown as the defendant number 1. See the practice. two sets of claims. One set of claims that is sending to the other defendants, and one set of claim type copy that has been arranged with this application. Let affidavit in opposition by opposite party number 2, supplementary affidavit by the petitioner hearing be filed within 2 weeks from the date reply thereto, if any circumstance. Then what came before this order report? To this affidavit in opposition, para number 3, same order has been typed. Para number 4, what stated that in view of the submission made by the learned advocate appearing for the opposite party number 2, your petitioner, obedience of his lordship, order files following documents to show his bona fide with regard to the service of the summons upon the said Gopal Mishra. What was the content? Only to produce before the original claim showing the convincing this honorable court that the one suit is pending against this particular opposite party number 2 as the defendant number 1. What came? Postal receipt. Gopal Mishra. Postal receipt, you send the one letter to Mr. Gopal Mishra. That doesn't mean one suit is pending. It is your practice.
Only that was directed to be produced.
Yes.
To remove the discrepancy, if any.
Yes. And what came before the court? Postal receipt.
No.
It is your choice.
Correct.
Order number 1 such and such, order number 7 such and such. Written objection against the court is saying to produce the claim, and they are producing the written objection against the violation of the injunction application. Skipping the route, they choose the branches. Wherefrom it would appear that that same Gopal Mishra has put his signature on the copy of the written objection, order number 9 dated such and such. Wherefrom it will appear defendant number 1 and 11 files Hazira, order number 11 dated such and such. Injunction hearing. From what document this court will come into the conclusion the suit is pending against this OP number 2 as the defendant number 1 before the Civil and Criminal Division Jalpaiguri in connection with the case number 142. And on the basis of that type copy, convincing the court that order has been obtained and the same has been entered. Moreover, my submission is that the serious allegation is there. There is no ground for quashing the FIR and the charge sheet. He's a 90 years old man. Why he lost the complaint? In his old age, entire property has been somehow taken in his name.
Okay.
I am not saying anything, I am not going into the merit, but all these facts should be scrutinized by the learned trial court. They can raise all these objections before this trial court also. So my humble submission, this application may be.
May I have my chance to rebut the submission of my learned friend? May Lordship may kindly turn to page 19 of my supplementary affidavit for a moment, my lord. For a moment, your lordship, I shall be troubling your lordship, lord, to take up page 19 of my supplementary affidavit. Written object, lordship kindly find it out.
Yes.
Page 19 of my lord supplementary affidavit. Lord, this is the written objection against the application under order 39 rule 2A, read with section 151 CPC on behalf of the defendants. We filed application under order 39 rule 2A because they were disturbing our position. But at the bottom of page 19, your lordship will see in the corner, your lordship is quite experienced, lord. This is the first signature is of Gopal Das. His age is about 84, 85. First signature is of Gopal Das. Gopal Biswas. Gopal Biswas, man. I'm sorry, Gopal Biswas. Lord, the second page, his signature is there. Third page, his signature is there. Even just Gopal Biswas. Even if suppose, Lord, there is an inadvertent mistake, Lord, Gopal Biswas cannot take, or my learned friend cannot take this plea that he was kept in dark or he was not aware of the proceeding when he has ended appearance by filing the or signing written objection. Can he say, "Lord, I'm putting this question to myself"? Under Lord, the CPC, your Lordship knows, Lord, your Lordship has wide experience that when this person has entered appearance, suppose, Lord, Lord, in case of a landlord and tenant, suppose the tenant has not received the notice to quit, and he enters appearance. In that case, Lord, the court will say that no, you have not received the notice. You cannot contest the matter. Not I'm putting this question to myself. From my little experience of the civil laws, but I'm putting this question to myself. Suppose the tenant has not received them, and of his own he enters into the suit and contests. Then the court can say that since you have not received the notice, you can't contest the matter. You yourself has signed the written objection. At the top of the paper, your Lordship will find he is the first signatory. And in will also he has signed. I have annexed all the papers. In will he has also signed. In all the papers he has signed, I have obtained the RTA information also from the department. In all the departmental documents, his papers are there. He has willingly showed, because there is a provision of sale also in the government's land. But if the lessee wants to sell the property, he will have to seek the prior permission. That permission was sought for. Permission was granted. My client deposited the amount. He took the possession. After everything, this gentleman, who happens to be one of the grandson of this Gopal Biswas. My client is also happens to be the grandson of the Gopal Biswas. They both are fighting, and falsely he has been implicated, and case after case has been lost. This is the problem. When he was in need of money, he was suffering. There was none to look after him. My client took all the troubles, all pains. And he has signed the written objection. It is none else. He himself has signed, knowing fully well. And this now he says that yes, there was a mistake, or his name was not there at the defendant number one. Might be. The learned advocate might have committed a bona fide mistake, or escaped his attention. And Lord, one of my juniors is there. If your Lordship kindly wants to see, Lord, one of my juniors is there with the copy of the right to information report. Ki naam ache junior?
Where is he?
Ki naam ache bolo? Lord, he is going. I'm seeing him on the screen.
What is
Ate Joseph ke? বলো না কি নাম আছে, আমি তো নাম জানি না। মনোজ দাস আছে? মনোজ দাস, আপনি নামটা আরটিআই রিপোর্টে জজ সাহেবকে দিন। ভাই মনোজ দাস, আপনি জজ সাহেবকে আরটিআই ইনফরমেশনটা দিন। জজ সাহেব বসে যাচ্ছেন তো।
not name, sir? He is saying right to information act. There is information that has been obtained from the office.
I am asking my client to give a copy to my learned friend also. মনোজ দাসকে বলো না, জজ সাহেব বসে থাকবেন নাকি? তো মনোজ দাসকে তো আমি তো দেখতে পাচ্ছি স্ক্রিনে। জজ সাহেব বসে থাকবেন কপির জন্য। দিয়েছে এত সময় লাগে খুঁজতে? Just boshe ache copy করছি।
I have got it, sir.
My lord, Lord, I'm extremely sorry, my lord, for wasting your valuable time, my lord. I'm sorry. You cannot approve it and reprove it both sides. Lordship, kindly see the letter dated 21st of November 2022. There is a mention about the deed of will that has been submitted by Gopal Das to the concerned authorities.
You have challenged that lease agreement. Executed.
So many documents have been procured by the this way, that way. All the things have been scrutinized and the charge sheet has filed on that.
Your suit, Gopal Viswas has filed a suit challenging the lease deed executed by him in favor of Monu Viswas.
Yes, see, when the complaint is coming before this criminal jurisdiction, then the next remedy is to cancel the deed. Criminal court will not cancel the deed.
That's all.
Much obliged, Lordship. Well, I'm extremely sorry, Lord, I could held up Lord, your Lordship for 2 minutes.
Thank you, sir.
I'm sorry for that.
That's the written objection as relied by the petitioner. I fail to understand one thing. One suit is pending before the court of law against some particular defendant. If the one defendant is not there, how this miscase has been started, I don't know. The application has also not been annexed with this supplementary affidavit.
Yes.
This also, and this signature, I think the signature again, it has been somehow, I don't know how it has been procured. We are getting the same cost title, Manoj Dag versus Sri Pradeep Vishwas. Whatever.
We will record that.
And
We will record you, sir.
This written objection, it has been sworn on 28th March 2023 by one Rahul Das,
Another grandson.
another grandson.
Those are brothers. Rahul and Manoj are brothers, fighting over the property of the grandfather.
But we should confine ourselves regarding that allegation, serious allegation which has been avoided in the conflict. That's
This.
My Lord,
mean-
my client is already on bail.
Already?
He is already on bail. He has been granted anticipatory bail. He is already on bail. There is no problem in that.
Because at the time of where he said that while he's facing the trial, that's why bail is free. Now it's come for quashing before trial.
This criminal revision has been filed by the petitioner under 482 of the Code of Criminal Procedure, hereinafter referred to as the Code. For quashing of proceedings in GR case number 1924 of 2022 in connection with this is which PS case number?
Naxalbari case. This is a Naxalbari police system. Case number
In
96.
connection with Naxalbari PS
Yes, ma'am.
police station case number 96 of 2022
My Lord.
dated 2nd May 2022 under section 406/420 of the Indian Penal Code within bracket in short IPC, pending before the learned additional chief judicial magistrate Darjeeling
Siliguri.
District, Darjeeling.
This is that.
Corresponding to the GR case number 1924/2022, as well as the charge sheet has already.
The brief fact of the case is that the de facto complainant opposite party number 2, Gopal Biswas, lodged complaint before the local police station alleging that the accused Manoj Das has obtained some signatures on blank papers and got executed some deeds in his favor. Comprised within plot number 73, measuring 384 square feet, and plot number 72, measuring 196 square feet, in Naxalbari DI Fund jurisdiction. These are the two properties?
My lord.
Upon such complaint being made, Naxalbari Police Station case number 96 of 2022 was initiated against the petitioner. Being aggrieved by and dissatisfied with the said proceedings, the petitioner has preferred the present revision for quashing of the proceedings. Mr. Asen Roy, learned advocate, appearing through virtual mode, submits that the de facto complainant is the grandfather of the petitioner, who made an application seeking sale permission of DI fund land before the subdivisional officer Siliguri, Darjeeling. Intending to sell his land within plot number 73, measuring 384 square feet, and plot number 72, measuring 196 square feet, in Naxalbari DI Fund jurisdiction. On such prayer, permission for sale of land was accorded by the concerned department.
P4, page 27, you also will find the concerned department allowed to register the land in favor of Manoj Das, and cost of land has also been deposited 81,200. P4 of my result application.
Page 4.
P4, my lord, page 27. I have annexed it. Lots will find it.
On such prayer
Permission for sale of land.
was accorded,
by the concerned developer.
and Sri Gopal Biswas was allowed to register 580 square feet of land in favor of Sri Manoj Das of Naxal Bari Hat. Since thereafter,
Next page also the deposited the amount that is there.
and the
Page
amount
28, page 28.
as required, amount as required was duly deposited
My lord.
for execution of the lease
Right.
deed.
My lord.
Since thereafter, the
Lease was duly executed.
son of Sri Gopal Biswas and his wife and sons and other relations raised objections. Sri Manoj Das filed a title suit before the learned civil judge junior division at Siliguri, being title suit number 142 of 2022, seeking declaration that the petitioner as plaintiff has right, title and interest over the property, is the absolute tenant as per provisions of DI fund under the government of West Bengal, and the defendants do not have any right, title, interest over the suit land. Thereafter, the present proceedings was initiated. This is after the suit. After the suit, the proceedings has been
Injunction is
initiated.
also there. Yes, after the suit, injunction is also there. Injunction is
After-
continuing.
Take it. After the suit, the present proceedings was initiated.
FIR was lodged on 2/5/2022. And this
Injunction is also there.
has been filed on 4/5/2020.
After.
2/5/2022 is the FIR. After 2
চলো
days,
কেটে দিন, কেটে দিন।
this suit has been filed.
Okay, এটা কেটে দিন। The entire dispute by and between the parties is civil in nature. And there are no such ingredients to attract the provisions of section 406 and 420 of the IPC. In light of his aforesaid submissions, he pleads for quashing of the entire proceedings. On the contrary, Mr. Sandip Mondol, learned advocate, appearing for opposite party number 2 de facto complainant, referring to the written complaint, submits that the petitioner was given responsibility for registration of the deeds, which the de facto complainant intended to transfer. However, taking advantage of such situation, he got the deed executed in his favor. It is also alleged in the written complaint that the petitioner has taken signatures of the de facto complainant in some papers. After completion of investigation, charge sheet has been submitted on the basis of prima facie materials. The allegations made in the written complaint needs to be tried to unearth the truth. And it would be a travesty of justice to quash the proceedings at this stage. He also indicates that the copy of the civil suit, being title suit number 142 of 2022, is not the original one. Stop. Gopal Biswas, Sri Gopal Biswas, opposite party number 2 de facto complainant, as per the certified copy of the plaint, is not a defendant in this suit. Stop. Therefore, there is no such civil litigation between the petitioner and the de facto complainant. Therefore, the argument advanced on behalf of the petitioner that the dispute is civil in nature is out and out unacceptable. He seeks for dismissal of the application. Mr. Niloy Chakraborty, learned advocate, appearing for the state, adopting the submissions of Mr. Mondol, learned advocate for the opposite party number 2 de facto complainant, submits that during the course of investigation, materials has been collected by the investigating agency and charge sheet has been submitted under section 406 by 420 of the IPC against the petitioner Manoj Das on the basis of primary materials. There are sufficient evidence against Manoj Das. He seeks for dismissal of the application. In reply, Mr. Asian Roy, learned advocate, submits that in their written
objection, Lord. At page 19 of my supplementary affidavit.
written
Supplement.
objection to the
Page 19 of the
application
supplementary,
under Order 39, Rule 2A,
which we filed. CPC to the
Sri Gopal Das, Gopal Biswas has put his signature. Therefore, it would be out of place to argue at this stage that Gopal Biswas is not a party to the civil suit. Para. Upon going through the written complaint, it is found that the de facto complainant has alleged that he gave responsibility to his grandson Manoj Das, bracket accused petitioner, for execution and registration of the deed now, Mr. Mondol, the dark numbers, LR dark numbers, this property is same.
Yes, sir. Same.
In respect of the properties in question. It is also alleged that Sri Manoj Das has taken signature of.
Lord, may I interrupt for a second, Lord? Subject to Lord's judgment. Lord, your Lordship will not take me amiss. Lord, in the lease deed, Lord, the government official has also put his signature at page 46. Your Lordship will find in the lease deed which was executed in favor of Manoj Das, page 46 of my revisional application. Page 46. Surjit Biswas, additional district sub register such and such. It is before him, the lease was registered. It was a registered deed. So no question of belying or belying that person Gopal Das or taking his signature on blank papers, etc. This was all fabricated and not afterthought. Lordship has got that copy of the lease deed also there. And it appears the signature of all the government officials, sub-registrar, and everybody is there. All have been falsified.
It is also alleged that Manoj Das has taken signature
of the complainant on some papers.
His thumb impression, everything that leads it also there.
De facto complainant alleges that after some time, it came to his knowledge that Sri Manoj Das has got the deeds of both the shops executed in his favor.
Petitioner is hammering is coming to the page number 52 and 55 of the original application. All the application has been made by this accused person to the concerned authority, subdivisional officer, DI fund subdivisional officer. It has been annexed. In the page number 54, where the signature of the. It is very unnecessary marathon hearing is going on. Stop.
And আপনি কি বলেন? Upon upon conclusion of investigation, the investigating agency, on the basis of prima facie materials, has submitted charge sheet against the petitioner Manoj Das. Now, coming to the other issue which has fallen before this court is that the plaint annexed to the petition is not the original one. Mr. Roy, learned advocate for the petitioner, submits that Sri Gopal Biswas is very much a party to the suit, since his signature appears in the written objection.
My lord.
Supplementary affidavit.
Objection of the violation, injunction violation. Not play.
Be that as it may, no documents after liberty being given by the court has been placed by the petitioner showing that the Gopal Biswas have been impleaded. Gopal Biswas is a party in the suit or subsequently has been impleaded in the suit. This court has perused the plaint annexed to the petition as well as the certified copy of the plaint annexed to the affidavit in opposition. It is found that Gopal Biswas is not a party in the title suit 142 of 2022. That apart, there is variance in the pleadings of the plaint appended to the petition vis-a-vis the plaint appended to the affidavit in opposition. Next. Mr. Roy, learned advocate for the petitioner, tried to impress upon the court not to take into consideration the opposition filed by the de facto complainant opposite party number 2, since the same has been wrongly mentioned as since the application has been mentioned as one under Article 227 of the Constitution of India. However, it is relevant to note that in the cause title of the affidavit in opposition, it has been indicated that the application is for quashing of the proceedings. Thus, it appears to the court that it is a misquotation of a particular provisions which does not out and out, which does not occasion for dismissal of the affidavit in opposition out and out. Para. Since the investigation of the case has culminated into filing of the charge sheet on the basis of prima facie materials, this court does not find any merit in the application. Accordingly, CRR number 19 of 2023 stands dismissed. Okay, thank you, Mr. Roy. Our interim order all connected applications. Thank you. Oh, এটা কপি দিয়ে দাও। এটার কপি দিয়ে দিতে বলো, রাইট ইনফরমেশন Section 5. Tomorrow. কালকে নেব। How many days delay? অ্যাপ্লিকেশন হেড করে সেকেন্ড অ্যাপিলের আন্ডারে করে দিন। কালকে ওটাকে উপর রাখুন, কালকে একটা টাইম দিয়ে দিন, সেকেন্ড অ্যাপিলে থাক, অ্যাপ্লিকেশন নিয়ে নেব। যা হেডিং আছে তাই থাক, এটা সিভিলের ফার্স্টে নিয়ে নেব। এটা যখন লিস্টটা বার করবেন ওখানে মেনশন করে দেবেন 2 PM। পাঁচশো করে রাখুন তো। রাইজিং এর আগে রাখুন ওটা।
But 30, but I have for the petition, my lord. But I have for this, yes, my lord. Am I audible, my lord?
Yes.
What is the plaintiff's petition? The side is super partition. Both the plaintiff as the defendants are co-sharer. Now on 20, the trial court order annexes C. My lord,
Annex C. Page number?
yes. My lord, that, yes, sir, 1 year, sir, I'm very sorry, my lord. Prior to that, D2 order. 21st November, your lordship, can you got it, my lord?
C, yes.
But that, I paid for an ex parte identity order because I specifically pleaded in the petition. The other co-sharer, they are trying to sell the property, not only they are making construction on the undivided property. The matter Lord, but I'm reading, my lord. Lord advocate, case record is taken up for hearing. the learned advocate for the plaintiff files arrest record of right and power of attorney and moves the injunction petition and order 31 rule 1 and 2, read with section 151. Peruse the note of surrender stating that there exists no caveat. Heard the learned advocate for the petitioner plaintiff at length on the injunction petition, carefully peruse the petition document. Issue notice upon the defendants calling upon them to so call now within 15 days, such as to why the PR made by the plaintiff for intimidation shall not be granted against them. The suit is filed for partition, separate possession, injunction, and consequence relief. From the content of the plaintiff, instant petition and submission made by the advocate for the plaintiff, it appears that the petitioner interest of the plaintiff and some of the defendants were recorded owner of the suit plots, and after their death, both the parties have inherited the suit property. However, due to the property being unpartitioned, the defendants in connivance with other defendants have been trying to interfere with the position of the plaintiff. However, on perusal of the documents filed by the plaintiff, the development of shares from the original is not clear. Moreover, the documents filed by the plaintiff is also not sufficient to support the claim of the plaintiff. Case made out in the plain to my mind and understanding does not warrant an ex parte in the injunction. Then, my lord, sub-notice is error. Then immediately, my lord, on 22nd, my lord, if I had an application for review, but I do not know why, then here's the impugn order, paper and appeal. Miss appeal number 63 to I also got it, my lord, impugn order. But appeal court also, my lord, also refused to pass ex parte ad interim. First, my lord, on 26 November 2024, the appeal was filed and injunction also moved. Then if you turn over, next page, order number 2. That is 27 November 20.
Yes. 11 December 2024.
Yes. Then, my lord, that was 28 November, that was date fixed for admission hearing. Then 28 November, but that matter was not heard. Then 7 December 2021 for admission hearing. The next page, my lord. The next page, my lord, that was also adjourned, fixed on 11 December 2024. Then, my lord, then that's important. 11 December 2024. Today's fixed for admission hearing from the office report. Appeal appears to have been filed within time and is in order being duly stamped. No caveat has been reported. Accordingly, instant misdemeanor appears and admitted. Wherefore, adding temporary injunction filed on behalf of the appellant is moved by the learned lawyer, heard the learned lawyer for the appellants, peruse the materials on record considered in view of the para capital F as mentioned in the application for injunction. This court does not find any cogent reason to grant ad interim injunction absence of other side. So there appears no urgency to come to conclusion that purpose of granting injunction shall be defeated by delay. Accordingly, wherefore injunction filed on behalf of the person refused at this stage. Not only said, but adjourned. It is refused. Issue notice to so cause. The next date was on 4th January 2024, 25, but nothing has been done on time, which I gathered from my client, my lord. My submission before your losses no. Israel versus Samson. That is 18 CWN. It is a suit for parties that admitted co-sharers. The suit for parties are entitled to get the money injunction, at least for a status quo. Otherwise, mischief will be done. And your losses know that our division in judgment, my lord, that is most possibly your losses was presided over by Justice Pranab Chattopadhyay. That is year 2004, Calcutta, 310. But first judgment, your loss is not Samson versus Israel. Israel versus Samson.
What is in para F?
Oh, para F, yes. Your loss can you see para F, injunction application, can you see? Para F, just no. I'm studying para F. Just a minute. For temporary injunction, that is misappeal application, and it's a D. Para F, yes, my lord. Inner page 4. No, that is not clear. Para F, yes, my lord. Inner page 4. Have you also got it? Injunction application?
Yes.
Inner page. That the father of the plaintiff, namely Muhammad Amanullah, son of such and such, died 30 years ago after his demise, leaving behind his wife, Samsin Begum, and two sons, namely Aslam Tariqul Aman, Tamir Hassan Imran, and three daughters, namely Rajya Sultana Begum, Rajya Sultana, Humuria Begum, and Fahimida Mehar Nigar, inherited the property and accordingly all the aforesaid legal heirs of the deceased Muhammad Amanullah, son of Muhammad Ismail, inherited the suit property by virtue of inheritance. That is wrong in success. It is typical of mistake at the Mohammedan law. That is a para F. Para F, not clear. And if also can you turn on next page, paragraph 5, that application, my lord. Can you see, my lord? HI. That the defendants are not only disturbing the plaintiff's injunctive share of land in the suit, but also trying to grab the entire suit land, forcibly covering the share of the plaintiff, trying to construct thereon construction, and also trying to transfer the suit land to the intending buyers, ignoring the interest of plaintiff, as well as fact no partition has yet been taken place amongst them. Then paragraph K also, my lord. My submission before my lord, but a learned district judge did not take into note other paragraph, other contents and other pleading also. All the paragraph F. Then K also. Is the K also in the last but 3 lines? But can you see that dependent totally refused such proposal, contrary defendants on that they tried to fell down some valuable trees standing in the Sudan, but they failed due to the strong resistance of the plaintiff. Now they are trying on. If the delay cause entered, mischief will be done. That is why humble submission before lost it. And usually my lord knows also suit for partition. Every courtier has a share in each of the corner.
Give notice.
Yes, sir.
Give notice to the defendants. Defendants have entered appearance in the suit.
No. Have not yet. Dependent opposite parties, well. 18 numbers.
Its civil revision has been filed challenging order number 5 dated 11th December 2024 in Miss Appeal number 63 of 2024 passed by Learned District Judge Jalpaiguri refusing to pass ad interim order of injunction in partition suit number 252 of 2024. Pending before Learned Civil Judge Senior Division Jalpaiguri. Learned advocate, so learned advocate appearing for the petitioner submits that it is the specific case, sorry, the plaintiffs and the defendants, it is to Karun, submits that the plaintiffs and the defendants are the co-sharers in respect of the suit property. The plaintiff filed a suit for partition of the joint property. In the said suit, the plaintiffs also filed an application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure for grant of injunction. Temporary injunction, along with a prayer for ad interim injunction. The learned Civil Judge Senior Division Jalpaiguri, first court কি বললো?
না শুধু আমি সিভিল যাচ্ছি
না না আগে এটা বলেছেন ফার্স্ট কোর্ট সেকেন্ড কোর্ট কি বলেছিলাম এটা at Jalpaiguri
সিভিল জাজ জুনিয়র ডিভিশন
না না সিভিল জাজ সিনিয়র ডিভিশন Jalpaiguri refused to grant ad interim injunction. Which was assailed in appeal before the learned district judge who also failed to allow ad interim injunction in favor of the plaintiffs. It is the specific case of the plaintiffs that the defendants are trying to encroach upon the share of the plaintiffs in the suit property and are trying to alienate the suit land. However, the trial court as well as the appellate court failed to consider the case of the plaintiffs. Being agreed by such order, the plaintiffs have preferred the present revision. Having heard the learned advocate for the petitioner, let notice be issued upon the defendants, opposite parties defendants. Petitioner is directed to serve notice upon the opposite party defendants to register speed post with acknowledgement due and file affidavit of service on the returnable date. List this matter before the next available circuit bench. Oh, but admit wording.
সিভিল ডিভিশন ইজ
Admitted issue notice করলাম ওখানে admit করুন।
মানে identity murder, I'm paying for identity murder. Otherwise, the same. Identity murder for limited period. Only status quo. I paid for. I'm not paying for anything more, but I know, my lord, at this juncture of my practice.
he prays for an order of status quo.
A nature and character and such nature, characters, possession, such as that. My lord knows, my lord also, my lord.
Having considered the suit wherein prayer has been made for partition, let there be an order of status quo as regards possession and nature of the suit property
And also possession, my lord.
for a period of 6 weeks or until further orders.
But possession also, my lord. We shall not decide.
Possession and nature of the suit property.
Yes, yes, I'm grateful. I'm grateful. I'm grateful.
Find the requisites for service upon the defendants.
Yes, yes, yes. I'm grateful.
এই আজকে 3:30 আছে তো একটু আগে এটা এফএমএটিটা একটু আগে ডেকে দেবে, ঠিক আছে? 3:30 আছে তো কিছু মানে চলছিল তো কিছু কন্টিনিউয়াস, তাহলে তুমি 3:10 দুটো চিন্তা অ্যাডমিশন নিয়ে তারপরে ঠিক আছে? সিভিলটা এখন ডাকুন, বলে দেবো। নেক্সট
Item number 31, proceedings senior date for Calcutta for sudden sickness of his father-in-law.
on the prayer of learned advocate for the petitioner, list this matter before the let the matter appear before the next available session.
Lordships. In item 32, and for the petition, yesterday your lordships article consider. Lordship, with the books of Fees Act, lordship, kindly see the page 7. Page 7, that is the provision of section 7, computation of fees. Now it says Roman 8, your lordship. Roman 8. For partition and separate possession of a share of a joint family properties, etc. In suit for partition and separate possession of a share of joint family property or a joint property, or to enforce a right to share in the property on the ground that it is a joint family property or joint property. If the plaintiff has been excluded from the possession of the property of which he claims to be a co-personal or co-owner, according to the market value of the share in respect of which the suit is instituted. Now you see page 41. Adjournment for fees chart, your lordship. Page 41, your lordship. We find your lordship 2,95,000 to 3,17,980. Then your lordship, if the fee increase at the rate of rupees 100 for every 10,000 rupees or part thereof, up to a maximum fee of 50,000 rupees. For example, 4 80,000, 5 lakhs, 19,900, every 1 lakhs, 1,000 rupees increased your lordship. But up to maximum 50,000. Now here in this case, your lordship, entire market valuation of the properties is 40 lakhs and above, and the plaintiff share 62.5%, that is approx 26 lakhs. 25 lakhs, 55,000 something, that is 26 lakhs. Now your lordship, if we calculate the chart, then your lordship, highest court fee is rupees 50,000. Up to 11 lakhs, 25,980, then every 1 lakhs, 1,000. Now up to 26 lakh, that means 15,000 in add, your lordship. If I calculate 40 lakhs and then your lordship 26,000 added, your lordship. Then up to 50%, 50,000. Maximum fee rupees 50,000.
If it is 40 lakhs, then also 50,000.
If 40 lakhs, yes, lordship. If the chart says, if the calculation is 2 crores, then 2 crores. Then every 1,000 rupees added, but up to 50,000, then that is a stop. Highest court fee is 50,000.
Oh. Then you have to pay 50,000.
50,000.
The court has directed to pay
50,000 rupees court fee stamp.
Now, what is the direction of the court to deposit?
2 lakhs. But it 4 says stamp duty for chargeable as sales stamp duty 2,45,301. Non-judicial stamp.
লাইব্রেরি থেকে বলুন তো 1963 ক্যালকাটা 46 দিতে জানেন তো? Yeah, 1963 Calcutta, page 46.
The time of filing of the suit, your lordship, in partition suit, rupees 80 is only applicable. That is as per section 7. Article 72, Article 76.
Is there any other fixed court fees excepting that 50,000? No.
No, your lordship. In the fixed at the time of filing, rupees 80. That is the section schedule 2, Article 76. As because at the time of filing, the court and also unaware about the market valuation, what is the plaintiff's share. Preliminary decree is also only for declaration of share only. Declaration of share. But after preliminary decree, when the final decree turn up, then at the basis of market valuation assessed by the district collector, then the court fees pays as per ad valorem court fees.
Anche? Shut down, pass over. Next to double. Next to double.
Lordship, I am for the petitioner.
What is this scan?
This is a scan for state of proceeding before the learned lower.
Please wait for some time. Let the judgment pass.
The gist is that the opposite party has filed a suit for permanent injunction before the learned civil judge junior division at Tufan. And after considering the contention uncontested, the learned lower court passed an order, trial court passed an order for status quo with the observation only that after perusal of the situation, this court is of page 60, may I kindly refer. Internal page 2 of the trial court's order. That the suit schedule land should be protected till proof of actual ownership of the suit schedule land. Considering all, it appears to me that balance of convenience and inconvenience is not in favor of both the parties. Against this impugned order was challenged before the learned additional district judge to Fangans in Miss Appeal Nong 1. In that, may I be permitted last after page 60, the order was passed a long order. I have only grievance with regard to additional direction. My petition is allowed, appeal was allowed on contest. And the status quo order was set aside. The additional direction was given. Both the parties are directed to place all the respective documents before the learned court, civil judge junior division Tufangans, Kuchbihar on 4/1/2025 in support of their contention by way of affidavit. Learned court of civil judge junior division Kuchbihar is directed to hear the parties appraised on the basis of affidavit and documents to be filed both the parties for determining the status.
Status of what?
Determining the status
of the parties.
Parties. Now it's a without evidence, without anything else, the additional direction has been given to determine the status. If the status is declared in injunction petition, what remains? Everything will be closed. And this will pose abuse of process. So for against that impugned direction, we have come up before your lordship and with a prayer for stay of proceeding. Otherwise, the entire matter will be frustrated and justice will be denied to the defendants.
No. You are in possession of the land.
Yes.
And the defendants also seek that they are the owner.
No, we are defendants. Defendants are appearing.
You are the defendant.
Yes, yes. Defendants are agreed.
Now the
Defendant
initial order was passed at the instance of the plaintiff.
Plaintiff. And thereafter that was set aside at the instance of the defendant with an additional direction. We have come up before your honor, before your lordship, against that partial modification. in page number 4, last but one paragraph.
Can you just take me through the relevant portions of the order passed by the appellate court? What was the contention of the parties? What is the case of the plaintiff?
Case of the plaintiff, may I
Respondent.
briefly state, case of the plaintiff is that plaintiff's father has purchased the property in the year 1969. And their document was lost. And with the notification of Kujbihar Registration Office, an LR record was prepared in the year 2016, claiming that he is in possession. And it is the contention that the defendants are disturbing and they are trying to encroach the land. So permanent injunction is required. This is the contention of the plaintiff. The contention of the defendant is that the defendants are in possession of the suit plot since their forefathers, and they have been recorded as permissive possessor in the year 2004 and also in the year 2022. It reveals from the documents filed before the appeal court and also trial court. That has not been considered.
Where is the porcha? Porcha you have annexed? Record of rights?
Record of right, we have possession, possessory right, anumotita, possessory right, and since long,
Where is that document wherein your status as a possessory?
that I have not submitted before your lordship today. If your lordship pleases, then I may submit later on.
You submit that. Because since their name has been recorded in the record of right,
Yes.
and you also claim that you have a possessory right,
Yes.
here is the confrontation of the contention of the buy-in between the parties.
Another thing I like.
Your only grievance is that at the stage of hearing of the injunction petition, if the status is determined by this court, then what remains to be adjudicated after trial?
Yes.
This
Yes.
is your grievance.
Yes.
You come up with that document.
Lordship, before that, I like to submit, and as soon as the property LR document is obtained by that very person, these defendants have objected to that recording. And on that recording, there were some mutation cases that is not traceable. And it has been informed by the BL and LR. Now, at least my submission, let them come and say what is their now actual condition. And in the meantime, the trial court proceeding may kindly be stayed. Appeal is allowed, but additional direction, we have come up before your lordship only for additional direction, and then this additional direction is completely abuse of process.
Then as per you, there should not have been an interim order at all passed by the court.
Definitely.
When the court has found that there is balance of convenience and inconvenience in favor of none of the parties.
None of the parties. No satisfaction is there. And so why the appeal court has set aside the order. Thereafter, appeal court.
Happy to have the
Given
order
the
set
additional-
aside by the appellate court. Now a direction has been given for determining this.
Yes.
Ashwin, this civil revision has been filed challenging order number 18 dated 16th December 2024 passed by passed by learned additional district judge at Tufanganj in Miss Appeal number 1 of 2023. In connection with order number 17 dated 29th April 2023 passed in title suit number 2 of 2022 by the learned civil judge junior division at Tufanganj. So and so learned advocate appearing for the petitioner submits that the opposite party filed a suit for permanent injunction. You have annexed the copy of the plaint,
Yes,
page number.
page number 30.
You have filed your written objection also.
Yes, yes. Written objection, written statement, everything, along with documents.
You will know. Permanent injunction against the defendants from dispossessing the plaintiff and or taking possession of the suit land. In the said suit, the plaintiff prayed for an temporary injunction wherein the trial court directed both the parties not to do anything over the suit land till the disposal of the suit. However, it observed that balance of convenience and inconvenience is not in favor of both the parties. Being aggrieved by such order, the defendant petitioner filed a misappeal being number 1 of 2023, wherein, although the misappeal was allowed, however, an additional direction was passed by the appellate court for hearing both the parties afresh on the basis of affidavit and documents to be filed by both the parties for determining the status. He submits that if the status of the parties is determined at the stage of hearing injunction petition, nothing remains to be adjudicated in the trial. Hence, the additional direction given by the appellate court is not sustainable. He seeks for stay of the order passed by the appellate court. Any timeline has been framed for disposal of this injunction? No. On perusal of the order passed by the appellate court in Miss Appeal 1 of 2023. It is found that while upon going through the order of the trial court while disposing of the appeal, disposing of the temporary injunction application, it observed that the balance of convenience and inconvenience is not in favor of both the parties. And it directed both the parties not to do anything over the suit land till disposal of the suit. In the Miss Appeal number 1 of 2023, moved at the instance of the defendant petitioner herein, the same was allowed on contest, and the order of the trial court was set aside. However, the learned appellate court directed the learned Civil Judge Junior Division Tufanganj, Kuch Bihar, to hear both the parties afresh on the basis of affidavit and documents to be filed by both the parties for determining the status. This court finds substance in submission of Mr. Mr. Das, learned advocate appearing for the petitioner, that at the stage of injunction hearing, the direction for determining the status would be deciding something before the trial. Accordingly, the order of the appellate court dated 16 December 2024 is stayed for a period of 6 weeks or until further order. Passing Miss Appeal number 1 of 2023. Stayed for a period of 6 weeks or until further orders. Stay the civil division is admitted, issue notice upon the opposite parties. Petition is directed to serve notice upon the notice of the petition along with copy of the application upon the opposite parties through registered speed post with acknowledgement due, and file affidavit of service on the returnable date. Let the matter appear before the next available circuit bench under the heading contested application. যেটা পাস ওভার হয়ে গেছে দিন তো কিছু একটু ওইটা করে দিই। Will be explained there as here too if the government is in a suit of partitions Article 17(6) of Schedule 2 of the Procedural upon the contest was C and the recidivism. I will answer the first part of the question last. Hmm. আর কি কোর্ট ফিজ একটা নিয়েছিল না? দেখুন তো। Hmm? It is West Bengal Court Fees Act. Which article will apply in your case? Will it be West Bengal Court Fees Act or Article 17(5) capital A of Schedule 2 of the Court Fees Act? 17 Roman 5 capital A of Schedule 2.
That is the fixed court fees.
Huh?
The partition suit, at the time of filing of the suit, the Article 17, Schedule 2, Article 17, now it's vegetable court fee, that is Roman 6. If the other suit, where it is the right slap the your worksheets in my case. Every other suit where it is not possible to estimate at the money value the subject matter in dispute and which it is not otherwise provided by this act, rupees 80. So your lordship, at the time of filing of the partition suit,
This is where you are reading?
lordship, page 54, lordship, page 54. Page 54, every other suit where
80.
where it is not possible to estimate at a money value the subject matter in dispute and which it is not otherwise provided by this act, rupees 80. Now at the time of filing of the suit, court fees is rupees 80. As because when the court passes the preliminary decree, declare the share of the parties and direct us to partition within metes and bounds at a certain period. Now they failed. Then the question of the final decrees came up. Then the surveyor is appointed, surveyor is submit his report. Then the court asked for the district collector to valuation of the property, entire valuation, and on the basis of the plaintiff's share.
Okay.
Now in this case also, your lordship, total market valuation 40 lakhs 88,000 something, and your lordship, the plaintiff share, total market valuation plaintiff share is 25 lakhs 55,000 217. Now as per section 7 Roman 8, the court fee chargeable as per the market valuation of the plaintiff share. Then in this case, court fees chargeable 25 lakhs 55,217.
So you'll be paying 50,000.
Because I am saying you before the court, as because the highest court fees is rupees 50,000. If I am calculate up to 26 lakhs, then it would be 26 for 11 lakhs 26,000 and plus your lordship 40,000, that means 41,000 approx. If I calculate the entire sub valuation, it is 40 lakhs and above, then it would be 52,000 something. So I pay before the court, I will pay the highest court fees of rupees 50,000 court fees stamp. This is undisputed. But court direct us to pay stamp duty of rupees 2 lakhs.
Sale for execution of sale.
Execution of the sale of the non-judicial stamp. So my question, no, in this case, in the partition suit, as the court direct drawn up the final decree, so court fees stamp duty is required, and that is highest court fees rupees 50,000. If I pay the non-judicial stamp, then only 7,600 and only 7,676 is required. But if court fee, then the charge is 50,000, highest court fee.
Thursday তে রেখে দিন। Thursday তে প্রথমের দিকে রাখো। অর্ডার করলো। কাল তো না? কাল তো Thursday, Friday. You take this book back on Friday, pass order. Today it's almost. কোনটা বললো? 29টা রাখুন তো।
Lordship, item 29, kindly take this matter on Friday. Mr. Ghosh is in election, court number 2.
What is your name?
Faith Rai.
On the prayer of learned advocate for the petitioner, who is Mr. Swarup Das?
He is Mr. Kushal Junior.
Release this matter on 24th.
Grateful lordship.
কি 30 হয়ে গেছে? যদি এমএসসি অ্যাপিল করতে তাহলে কবে করবো? ওকে না ফ্রাইডে দিন নেবো। Friday. Yes, sir.
Mention one thing. Today, CO is, my item is at the end of the. So
Which one item number?
34.
34. We have almost reached. 34.
Today,
It will retain its position, accepting that matter of court fees, which I have put in earlier. After that, your matter will be there.
Yes.
আর তো কোনো ম্যাটার পাস ওভার কিছু নেই, আর এটা থাকলো। ওকে, ওনারটিতে দেখবে উনি ফ্রাইডেতে, if it is not taken up, then you mention on Friday, we can update on the coming week.
Friday I will not be here.
You will not be there. Ask your
Your
junior.
lordship, fix on.
Ask your junior to remain present. I'll fix a date as per your convenience.
27.
You just convey him which date you prefer, on 27th or 28th, whichever. You have to prepare the list sitting down right now.
Lordship.
1, 2, ঠিক আছে।
Lordship, before your lordship rise, lordship, actually have small submission, lordship. Actually, FMT matters, lordship, if your lordship take up the FMT matters from 2 PM, so there is a chance for hearing for few matters.
ওই তাহলে
There are many hearing matters, lordship. If the paucity of time is not possible for lordship. They take up.
see on Friday, we'll see. There are also civil revisional applications.
If you lordship take up the matter too, I think.
ঠিক আছে, যেমন আছে তেমন। চল।
Great lordship.
Judgment will be given.